Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about car crashes. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Edmondson took his son out on a motorcycle. The motorcycle wasn't fitted for two people, but he fashioned a seat of his own, strapped his son into the seat, strapped his son to his person, and rode the motorcycle. Unfortunately, he was involved in a crash with another vehicle. At trial, the driver of the vehicle in the crash was found to be negligent and found to be liable for the injuries both to Mr. Edmondson and Mr. Edmondson's son. However, the driver of the other vehicle was also not successful in arguing that Mr. Edmondson was contributorily negligent in riding his motorcycle with his son on it, even though the motorcycle was not equipped to have a passenger. This case raises very important issues about the concept of negligence. Typically, in Canadian law, negligence applies to actions that are foreseeable. So you have to pay for the consequences of the foreseeable outcomes of your negligent behavior. But how is it foreseeable that somebody is going to be engaging in their own negligence or be engaging in conduct that a motorcycle is not equipped to do? It draws an interesting line between what you can reasonably expect, a vehicle carrying passengers, and a vehicle that is not equipped to carry passengers, carrying passengers. And this is a particular point of nuance that the Supreme Court of Canada should have gotten into. We don't see many cases on contributory negligence or on the distinction between causation and foreseeability that go to the Supreme Court of Canada. And it was an opportunity for further clarification in this area of law that comes up a lot at the lower court level, but unfortunately hasn't had a lot of treatment from the nation's highest court. And unfortunately for the driver of the vehicle that hit Mr. Edmondson's motorcycle, it means that she doesn't really have the answers that she was seeking in relation to how Mr. Edmondson's negligent behavior should have affected her civil liability in relation to the crash. Hopefully it doesn't take another case with tragic consequences such as this one for the Supreme Court of Canada to take the opportunity to further clarify the law of contributory negligence and foreseeability in our civil litigation system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.